Hello and Assalamualaikum. I would like to introduce to you about the domestic inquiry. The domestic inquiry is a process that refers to an inquiry that is carried out by an employee into the actions of employee while they are on the job. Domestic inquiry is something that frequently occurs in the working world. Because of this, the employee who is now defendant has opportunity to provide his side of story. Employees will have the option to provide their side of the story and defend themselves against the allegation as a result of this. It is essential to have a positive personality and adequate self-awareness in order to exercise courage, which at the center of all ideas that are pure and sensible. As a consequence of this, an employee working for an organization thought to make use the virtue of bravery as a value in order to fortify and improve the integrity of both the public service and the nation. Malaysia, in the accordance with the rule of natural justice, which state that no one may be found guilty without first being given the opportunity to defend themselves. The context of the eye is applied as follows. 1. The employee who is being accused should have received adequate notice of case they are required to satisfy. Number 2. The employee must have a reasonable opportunity of being heard in their own defense. The judge should listen to both sides of the argument, and this include the opportunity to face and challenge their accusers, witness, and whatever evidence there is against them. Number 3, an impartial tribunal, which is defined as a person who is neither directly nor indirectly connected to any of the parties involved in the case, must preside over the hearing.
My name is SUZIERDIYANA binti SUARDY. My metric number is 2020996093. I want to talk about importance of domestic inquiry. The first is the employers ensure that employees are treated fairly. Aside from being a statutory obligation, domestic inquiries are reliable proof that an employer has taken necessary steps to ensure that an employee is fairly treated should alleged misconduct be reported. In the event that an employee filed a case against their employers for wrongful or unfair dismissal, a judge will definitely look to the domestic inquiry for proof that an employer's actions were fair and adequate. The Employment Act of 1955 state that conducting a domestic inquiry is a legal requirement. The Act does not specify how one should be performed or what constitutes a sufficient true inquiry under the law. As a result, there is a lot of room for interpretation when it comes to how to conduct a domestic investigation, which will normally be determined by the circumstance and the severity of the employee's misconduct. This scarcity of legal resources may perplex employers and human resources, but it should not dissuade them from conducting a true domestic investigation, as the consequence of failing to do so can be served if an employee filed a wrongful or unfair dismissal lawsuit. The second importance of domestic inquiry is the employee is given the right to know the complaints against him or her. During an examination procedure into claims brought against him or her, an employee has a right to procedural decency. This means that the employee has the ability to defend themselves against claims brought against them. That employee, for the information, must be given the substance of the protest as well as all substantial. vital and critical material that needs to be addressed. It is critical that the workers be informed about the claims, nonsense, so that he or her can respond appropriately before a decision is made. A worker's privileges are clear if an examination involving claims result in an accusal. The factors for determining whether a dismissal is harsh, unjust, or unreasonable according to Section 387 of the Fair Work Act 2009 include whether the employee was given an opportunity to respond to any complaints leveled against him or her. This was determined to be procedurally reprehensible and an out-of-line accusal was sustained. After the inquiry is complete and the employee has the right to examine the investigation results so that he or her can respond. If the allegations are found to be true, the employee must be informed and told of the course of action that will be followed to remedy the situation.
Cases related to domestic inquiry on account of Tavian by AP Subramaniam v. IOI Building Services, Tava Selvi Parajasingam and Tan Hawei survived in defending IOI Building Service in an out-of-line excusal assurance by a prior employee who has been accused for viciousness into the bank in a responsible way. Another case is the Industry Court declared Hosni bin Yunus by Malayan Banking Berhad in the later case that the claimant's employment with the bank was removed due to sexual harassment. The criteria in sexual harassment proceedings, according to the Industry Court, is not whether the claimant intended to harass, but if the approach was unwanted.
Domestic inquiry is an internal investigation process that is launched when an employer needs to determine whether an employee has committed an act or acts of conducted. Employers must perform a proper investigation to determine if an employee is responsible of wrongdoing before dismissing.
Assalamualaikum, my name is NADIATUN ABDUL HALIM. Today I will present the title that has been given to me, which is Process Flow in Malaysia. A domestic inquiry is an internal investigation process that is launched when an employer needs to determine whether an employee has committed an act of conduct. Employer must perform a proper investigation to determine if an employee is responsible of wrongdoing before dismissing or imposing a major punishment on them. According to Section 14 of Malaysia Employment Act 1955, a domestic inquiry should always be viewed as a last choice if the matter can be resolved through dialogue with all parties involved. Now we go to the first point, the issue of a show cause letter. A show cause letter is one that shows the specific ground and reason for worry. As the term means, the letter is also used to summarize the charge of wrongdoing in a clear and complete manner, as well as to create a deadline for an employee to tell their side of the story in informal writing. To avoid unnecessary complication, sending a show cause letter is a sensitive process that should be conducted carefully. For example, a straightforward and easy to understand language that is simple and clear, and in light of the claim misconduct, a strict demand and time for the employer to provide a writing response and explanation and more. The second point is suspension of the employee. The suspension is only necessary if the employer believes it will prevent the investigation from being damaged and or prevent the employee from committing future conduct. According to the Employee Act, the employee can only be banned for a maximum of 2 weeks and get half pay during that time. If the employee is eventually found not guilty, the company is responsible for the outstanding salary. That's all for me. Thank you.
Hi, Assalamualaikum. My name is ALYA AMIRAH binti SUHAID and my number card mature is 2020-990-369. Okay, to continue, the point of the number 3 is preparing for domestic inquiry hearing. It is employer writing explanation and response to the show cause letter is acceptable, and employer may begin to plan into a domestic inquiry hearing. The next is a point of panel members. During of domestic inquiry hearing, the employer will be required to choose and appoint a panel of senior workers and management members to assess and make a final judgment. For example, panel members should be fair and as a result come from different departments than a parties involved. Okay, that's all. The point of number 4 is carrying out of domestic inquiry hearing. In domestic investigation are usually modified after court cases. There will be two sides. The government is acting on behalf of the employer and the defending acting on behalf of the employee, which consider accused employee. Both sides should be entitled to bring witness and evidence and present evidence to back up their claims. That's all. Thank you.
As a conclusion, domestic investigation are of the utmost importance in order to prevent any future wrongdoing on the part of personnel working for the organisation. This is due to the fact that other workers will be taught a valuable lesson if they witness any worker engaging in appropriate behaviour while on the job. Even though the employee has the right to present a defence, the decision regarding the employee's future with the company will be made by the company management if it is determined that the employee committed the offence. It might not be essential in every circumstance, particularly in situation when wrongdoing is very modest, such as employees paying and receiving bribes among themselves. However, the amount of time utilized will be larger if there is several wrongdoing that cause any accident in the organisation, and an internal investigation will need to be conducted. This is a legal commitment that is forced on the business because it is a legal obligation forced on the business by Malaysian law. In the event that a company does not have a home ground request, the employee will be at loss as to how to react to the complaint.